The COVID-19 pandemic has greatly affected the lives of many people in different ways. A number of measures have been put in place to stop the spread and impact of this virus. Two such measures are what I shall call the exit ban, which stops Australian citizens and permanent residents from leaving Australia unless they are granted an exemption or an exemption otherwise applies to them, and the entry ban, which stops most temporary Australian visa holders from coming to Australia, again unless an exemption applies to them or they are granted one. So what is the legal basis for these travel restrictions? In the case of the exit ban, a determination made by the Minister for Health under the Biosecurity Act of 2015 sets out that as of midday on the 25th of March 2020, an overseas travel ban is in place and lays out the exemptions which may apply or be granted. As for the entry ban, which has been in place since 9 p.m. on 20 March 2020, an equivalent determination does not appear to exist. Instead, leaving aside the government announcements which introduced the entry ban, official information about its existence and the availability of exemptions is only set out on the website of the Department of Home Affairs. Indeed, the entry ban appears to be wholly the exercise of non-statutory executive power by the Commissioner of the Australian Border Force under the Constitution. Of course, those impacted by the entry ban have otherwise been given permission, that is a visa, by the Minister for Immigration or one of his delegates, allowing them to travel to and enter Australia. This begs the question, can the exercise of non-statutory executive power by the Commissioner of the Australian Border Force to impose the entry ban trump the exercise of statutory power by the Minister for Immigration or one of his delegates to grant permission, that is a visa, to a person to travel to and enter Australia at a port? Australia's migration legislation provides that notwithstanding any statutory power, the Commonwealth retains the right to protect Australia's borders, including by ejecting people who have otherwise crossed those borders. You might recall the Tampa case from back in 2001, when the federal court ruled on the government's power to prevent the entry of asylum seekers to Australia who were aboard a Norwegian ship. In that context, where the people seeking to enter Australia had not been granted permission, that is a visa allowing them to do so, a majority of the federal court ruled that the Commonwealth did have the power to prevent their entry. Whilst there has been some further obiter consideration of the exercise of non-statutory executive power in this manner since, that has again been in the context of those who had not otherwise been granted permission, that is a visa, allowing them to travel to and enter Australia. I'm keen to hear your thoughts on the legal foundations for the entry ban, as well as the impact and effect of Australia's travel restrictions more generally. Please feel free to share your views in the comments section, and thank you for watching.